Welcome to Strategic Justice in Action with David Senoff.
Hey everybody, welcome into an all-new episode of Strategic Justice in Action with David Senoff, the founding partner over at the First Law Strategy Group. I'm your host, Mike Leon. David is a plaintiff's attorney focused on appellate advocacy, insurance bad faith, and public policy litigation that's been holding corporations and governments accountable. And in today's episode, we're going to be talking about how attorneys, associations, and advocacy groups can really shape the law, even when they're not directly involved in a case, through amicus briefs. What the heck is amicus briefs? David's going to explain in just a second. David, it's good to see you. So for the lawyers who haven't been a part of one, or even for people that are listening to this that don't know what is an amicus brief, and why do the appellate courts welcome these outside perspectives?
I'm Mike. Good to be here. Good to be with you. And that's a really good question because nobody really knows what it is. Amicus briefs it's a Latin word that, of course, goes back to the English justice system. The full phrase is amicus curiae, which just means friend of the court. And so these briefs are written on behalf of these groups. So the groups who have opinions that may not be, 100%, represented by one of the two parties can get their point of view expressed to the court, whether they support the person that's appealing or the person that's defending the appeal, and explain more what the result will be of an appeal in real world terms if the court rules one way or the other. So, for example, you get small businesses, large businesses, in certain cases, will write briefs on behalf of one side or the other to explain, well, if you rule in favor of this side, here's how it's going to affect our business going forward. Or here's what the real world effect is on individuals who will have cases like this in the future, and what your decision, what the long-term effect of your decision might be on this group. And it really is an effective way for not just businesses, but unions, fraternal organizations. I mean, I represented one time, I wrote an amicus brief for the Loyal Order of Moose, which is a fraternal organization here in Pennsylvania and nationally. I've written them for unions, and I've written them on behalf of pharmacies in cases that have to do with pharmaceutical reimbursement by insurance companies. So all of these disparate groups, which you might not think have an interest in a particular appeal, sometimes do, and they want to express that opinion to the court.
So given your experience writing for both plaintiffs and defendants, these briefs, when does the outside input genuinely help the court in your estimation, and when does it backfire?
I mean, I think it generally helps the court in cases where you can see that the issue is a much larger issue and important to more than just the two parties to the appeal. So, for example, in a case like, a car accident or a medical malpractice case, usually those issues are very fact intensive to the parties and don't really raise a question where other people might want to express their opinion. But if, for example, it's a car accident case where the plaintiff is suing the manufacturer of the car because they say the car is defective in some way, and this car is, has been sold for years and years and years, well, then maybe the manufacturer of the car, on the one hand, wants to file an amicus brief, not so much to defend their product, but to explain what the result will be of the decision. Other times you have cases, for example, against health insurance companies or any kind of insurance company. Sometimes the policyholders of that particular insurance company want to express their opinion to the court about what will happen depending on what the question about the policy is even though, the case isn't about them, but they can see that the case could be about them in the future, right? If they make a claim under the insurance policy. So all of those types of things are basis for amicus briefs.
How do you decide whether to file these on your own or join a coalition? You mentioned before some organizations that are making these single submissions. Like, how do you decide?
Well, so normally one of the two parties will reach out and say, look, we could really use an amicus brief on this particular issue because it's important in the case, but it's tangential to what the main issues are. Sometimes, and then, they'll suggest people or organizations or groups of people that they think might be interested in it. Normally that happens, I'll get a call because people know that I've represented in the past a group that might have an interest in this upcoming appeal. On the other hand, sometimes you as the attorney can see what the case is about, just as an attorney on the outside looking at the appeal, and you know that one of your clients has an interest in this. You might call the client and say, like, hey, this appeal is coming up. Maybe, given what the issues are, you might want to consider writing an amicus brief. Often the amicus brief, not too often amicus briefs are written by individuals. In other words, it's never just like Joe Smith as the amicus, unless Joe Smith has like a very specific interest in the issues that are being decided in the case. But oftentimes, more often, the issue is so big that it has more to do with, groups, businesses, community groups, for example, groups of like the trial lawyers, in other words, Pennsylvania trial lawyers oftentimes will write amicus briefs on behalf of their clients, even though their clients aren't named in the briefs because, they have cases with similar issues to the ones that are on appeal.
So, in your estimation, what are some of the most common mistakes that these lawyers make when they're drafting these briefs? And then let's say the briefs, they're meant to influence precedent rather than repeat the party's argument. What are some other common mistakes that you've seen lawyers make?
Well, that's the number one mistake, right? Is repeating the argument of the lawyer on whose side you're writing, on whose client side you're writing for. The other mistake is arguing so much of the facts of the specific case that you're writing on behalf of that you lose the forest for the trees, right? The amicus brief, the purpose of it is for the amicus party to sort of fly at 30,000 feet above the case. Right. So the facts are the facts, but you want to give the court a 30,000 foot view of the issues. And you want to explain the law and how a precedential decision on a particular issue will affect the law, but from a very, very high view, as opposed to a very down in the weeds, case specific, fact specific way that the parties will take care of, right? The parties will always take care of that. So as the amicus, you want to sort of pull back, zoom out, if you will, and show the court what the landscape looks like around the parties.
David, let me ask you from a policy standpoint here. How have these amicus briefs shaped significant areas of Pennsylvania or maybe even national law over these last few years?
In Pennsylvania, for example, there have been fights about what we call venue and jurisdiction. In other words, where in the state a case can be brought. Amicus have been very instrumental in those cases. Tax policy, right? Businesses have been instrumental in cases that involve tax policy, property tax policy. More broadly, in the country at large, when you see a lot of these cases in the US Supreme Court, particularly having to do with fights with the president or one of the president's policies or one of Congress's policies, a lot of times you'll see various groups of attorneys general line up as amicus and say, hey, wait a second, let's discuss this because here's what it's going to be like for us on the ground to try and enforce a decision like this because we're the law enforcement, we're the chief law enforcement officers of our state. Even in cases, for example, like opioids or mass torts, a lot of times you'll get amicus briefs from attorneys general who will talk about what the effect of opioids or whatever the issue is has been on the state. And then finally, I would say probably one of the largest nationally issues is voting rights. So voting rights and voting rights cases and gerrymandering and map drawing always draw a lot of amicus briefs, both at the state and national level, because as you can imagine, right, I mean, everybody has an interest in a decision that affects your right to vote and affects where you're going to vote and how your congressional district lines are drawn and your state house lines are drawn. And so in those cases, you see a lot of amicus briefs.
Yeah, we're seeing that play out now. I'm curious then, because these briefs oftentimes they kind of reflect the collective position, let's say, of maybe an association or somebody like that. How do you balance then the advocacy part of this with accuracy so that the credibility of the submission is truly preserved?
Well, so that's one of the sort of lines you have to walk, right? So in other words, you can imagine when you're unbounded by having a client who is going to be directly affected by a decision. In other words, one of the parties, right? You could write a brief that, when people touched it, it flamed up, right? Like you could, on voting rights, on any kind of civil rights or liberty issue, you could be Thomas Paine, right? But most clients don't want you, particularly associations and businesses. They don't want that. What they want is they want a dispassionate view of their view of the issue, but in an advocative way. And so it really is sort of an art to writing that, because on the one hand, you want to be Thomas Paine, but on the other hand, you don't want it to be so over the top as to be ignored by the court, number one, or to be, not approved by the group of people that hired you to write the brief. And so in most of the cases where I've been involved, where I represented an amicus party, we submit the brief either if it's a company to, the general counsel or some group within the company. The associations usually have a board of directors. They read it. They want to decide, is it too much? Is it not enough? And so there's a lot more client scrutiny, and for good reason, over amicus briefs, because you're not a party. And this will reflect on your business or your association in the future, because this is what you are saying. It's publicly filed, and anybody can read it. So you have to sort of balance out the advocacy on the one hand with the reality of who you represent and why you represent them on the other hand.
So, David, as we wrap on this episode and we're looking ahead into time now, where do you see the role of these amicus briefs as they evolve, especially as the courts are handling more complex, policy-driven litigation? Where do you see the role of amicus briefs playing out?
I can only see that it will increase in the future, particularly because we see these policy fights taking place not so much or not as much in the legislatures of the states or Congress, but more in the courts, right? It seems to me that the legislatures generally do what they do, Congress does what it does, but then the courts are the final arbiter of whether some policy is going to move forward. And so when a policy issue is in front of a court, that only means that more people, whether they're associations or businesses, have a specific interest in the case being decided one way or the other, not just the parties. And as that kind of litigation increases, I think the power and the necessity really of amicus briefs in those cases will only continue to rise.
David, thanks for the time and insights breaking this down. We truly appreciate it as always.
Thank you. It was good to be here.
And thank you to everyone out there for listening to this installment of Strategic Justice in Action. If you want to learn more about what David does and the team does over at First Law Strategy Group, do me a favor, visit firstlawstrategy.com. Before you go, don't forget to like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. See everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.